Okay, we're ready to go. So good morning for those guys in the class, and I guess good evening for those guys watching on Wednesday. So today is a review. Did everyone download these? Yes? Some of you are nodding. Okay, I put them up on WebCT, I think on Thursday. So you can ask any questions as we're going through. I've just summarized key points, and then I've given you those 3 multiple choice. I assume those of you who downloaded the slides have already gone and probably answered those multiple choice. So the final exam is next Monday, almost right at this time, 9 a.m. in the Alumni Hall. So we're all together. So look, there's 2 rows. There's going to be numerous exams written in Alumni Hall. So you'll need to just to make sure you're at the right row for section A, and then for those of you on CUTV, there's separate rows for you in Alumni Hall. So you will see me there. So if you don't see me there and you start writing a 2400 exam, then you know you're in the wrong spot. Okay? There is another 2400 exam being written the same date, the same time, but a different location. So everyone here should be at Alumni Hall. As I already mentioned numerous times, but let me repeat it for those who don't know, it's going to be 80 multiple choice. There's 1 bonus question that you can answer or not. You'll just get a bonus mark if you answer it. Well, if you answer it correctly, you'll get a bonus mark. Chapters 7 to 12, and I'm going to go through each of the chapters right now, so you'll for sure know. It is based on the 2nd edition. I'm actually quite surprised the number of people who are not using the right textbook. So when I get emails saying, you know, the chapters don't match up, my assumption is that you're using this textbook here, the 2nd edition, and the 2nd edition study guide. So if you're not, obviously the chapters don't match up because we changed the chapters in the 2nd edition. So when I say chapters 7 to 12, it's the 2nd edition chapters 7 to 12. And it's the lectures from week 6, lecture 10, until last Wednesday. Okay, any question about the format of the final? Okay. Okay, so do you want me to, I'll go through this, and as I go through it, if you have questions, you can certainly ask me what questions you may or may not have relating to the topic that we're going through. I think I'll probably spend a little more time on the first part of the course right after the midterm, because we just talked about homicide, we just talked about psychopathy in the last week or 2, so hopefully that's fresh in your memory. So I don't need to spend too much time on that area. So let me spend a little more time on the first 2 sections or 3 sections. So move back, about 6 weeks ago, 7 weeks ago, to chapter 7. This is where we talked about juries. In chapter 7, there is nothing in chapter 7 on the CSI effect. Okay, so I added that. So it's not in your textbook. Yes, there's a question on the CSI effect on the final. And the CSI effect was the trend that people who watch those type of TV shows, Law and Order, CSI, I don't know, Criminal Minds, Cold Case Files, whatever, that these individuals come to expect hard physical evidence being entered in a trial. So DNA, blood analysis, ballistics, whatever. And then when they don't get that, okay, so there's this expectation they would see that type of evidence. When they don't see that, remember only in about 10% of cases, right, we have that sort of evidence, then they are less likely to convict. Okay? So it's really the expectation that moderates the relationship. I also talked about the Kim et al. Study. That was the 2009 study. That's where I had a couple of slides about this recent study. These were actual jury-eligible individuals, where it was a jury simulation study, circumstantial evidence study, where they were looking at direct and indirect effects. Is this okay? And so what they found was, they found, again, evidence for an indirect effect, not a direct effect. So it wasn't CSI viewing that predicted less convictions or fewer convictions. It was CSI via expectations, beliefs, then fewer convictions. Okay? Any questions about CSI effect? Yeah. Kim et al., 2009. Jury selection, there's two main types of jury selection, right? You hire a jury consultant. We don't do this in Canada much, but if you have a lot of money, this is probably would work in your best favor for a defendant to hire a jury consultant to come in and work with your team to try and select the appropriate or the ideal juror. And you can do this based on broad-based information. So the one personality trait you want is authoritarian. If you're a Crown, that would be pro-prosecution. Or you can do it on case-specific. So you can have focus groups. You can hire your consultant to phone a random segment of the population, right, and see how they would respond. So it might be that you want to target middle-age African-American males. Okay, you're the defense representing an individual. That individual would be most likely to vote after you present all the salient case details to acquit or not guilty, a vote or not guilty. So certainly case-specific, just think of, I want to look at the individual case. I want to get information on how most people are going to vote, and then I'm going to try to select jurors who will be in my favor. And you can do this from the prosecution side or the defense side. Okay, is that pretty straightforward? There's lots of, at the front end of the jury trial, there's a lot of details about the Jury Act. Don't worry about that. Lots of, about how much payment you get for being a juror. I don't care if you, I guess you care if you're a juror, but I'm not going to ask you any questions like that. So there's a lot of picky details at the front end of that jury talking about procedures. Fundamental features, this is a Supreme Court ruling. Fundamental features of a juror in Canada is that they're representative of the community. Okay, so we want to get a representative sample of the community. Okay, so that's important to know. And we want to make sure that these people are impartial. Okay, they're not going to have any specific biases or prejudices that will affect their decision. They should be partial or impartial. They should come in, listen to the evidence, and then based on the evidence, make a decision. Okay? If there's any risk that they might not be impartial, there's three options that can occur. Stay of proceedings, where we just delay the trial. Hopefully then the media interest, typically it's due to media interest, so the media interest will go down, and then we can hold the trial. That's really rare to have a stay of proceedings, because then you're waiting, who knows what's going to happen to the witnesses, right? Maybe the defendant. You don't want to wait too long, right? Because we already know what happens in terms of people's memory. So the change in venue option is moving the case, like the St. Catharines, the Bernardo case, there was a change in venue. Everyone in St. Catharines knew about what happened in the Homolka-Bernardo case. Humongous media. Even though they put a blackout, it was all being, you could get all the information on the internet. So they moved that case from St. Catharines because they didn't think they could find a group of impartial jurors there. They moved it to Toronto. And even though so that's one option. But they acknowledged, even if we moved it to Toronto, right, still people in Toronto heard about the Bernardo and Homolka case. So then what happened, they developed a set of questions, because they believed somewhere in Toronto we could find a subgroup of 12 people who would not be biased. So we need to question them to make sure they're not biased. And this is a very unique, it's called challenge for cause. And challenge for cause is not the judge that does the questioning, it's the jurors themselves. Okay? So they would ask the potential jurors are these questions, and then they make a decision, yes, I think you're biased, no, you're not biased, yes, up there you are biased. Okay, so it's the jurors that make that decision. The other thing I mentioned in the class that's not in your textbook, and it might be, yes, oh, well, maybe I mention it later. Oh, no, that there's different types of prejudices. So there's specific interest. Okay, someone has a direct relationship with defendant. What case is in your textbook and what case did I talk about in class? That has specific interest in the outcome. Do you remember her name? I can even remember the picture I had of her up. She was in BC. My heading said nudge, nudge, wink, wink. No, you guys? Okay, so say it louder. Jillian Guess. So Jillian Guess. She's in the textbook. I talked about her. She would be an example of an individual who is prejudiced because she had a specific interest, right, in the case. I also talked about individuals who have a generic bias. So they maybe have a generic bias against a specific group of individuals, sort of like a racial stereotype bias. Normative bias, or a prejudice, a community sentiment against an individual. So certainly you should know those as well. Okay, any questions before I move on? Okay. This is pretty easy. Everyone probably will know there's 12 on the juries. We have to come to a unanimous decision. So if I ask you how many juries, easy, 12, unanimous decision. Jury nullification. Now, I didn't really talk about this in class, but it certainly is described in your textbook, where juries make a decision that goes counter the law. Okay, so the Latimer case, remember this was the individual who killed, I think it was his 12-year-old daughter, put her in the pickup truck, put the hose from the, and gassed her to death. Right? He was convicted of second-degree murder. It's pretty obviously there was some planning involved, right? She was disabled. He put her in the pickup. The jury came back. So an automatic sentence for a second-degree murder is life, 10 years minimum. Okay? And certainly the jurors can come back and say, well, instead of 10, I think this person had 15. I think this person should have 18 before they're eligible for parole. Okay, but in this case, the Latimer case, they came back and said, I think he should serve 1 year. Well, that was not an option. The option was 10 to 25. Okay, so that's jury nullification. So you should know those terms. All of these terms, typically, that I want you to know, you should know all the terms that are highlighted on the margins of your textbook. They're also in the glossary. If there's something highlighted in bold in your textbook, it's also along the margin. Okay, so make sure you know all those terms. Certainly, jury nullification would be an example of that. Studying jurors, there's 4 different ways described in the textbook. Post-trial interviews, you see this on TV a lot in the States, right? So there's some large study or large case trial. Afterwards, you see the group of 3 or 4 juries willing to talk to the media. They talk, and then they disclose information about why they convicted someone or why they didn't convict someone. Certainly, that would be one of the better ways, right, to do research. However, we're not allowed to, and jurors are not allowed to disclose information in Canada. So I can't do that sort of research here. The archival research, you could go back and code court transcripts about studies. So you want to look at whatever, right? The physical attractiveness of the defendant and the likelihood or less or more likelihood that the individual gets convicted. If you have a photo maybe of the person in the archives, in the court transcripts, then you could maybe do this sort of study. The most common type of study is simulation research. This is what all the researchers do at the universities. They call you in. They give you a vignette. You go through that vignette. You answer some questions. And I described the Kramer et al. Simulation study, looking at pretrial biasing information, factual versus emotional. So you do need to be familiar with the Kramer study. And there's also field studies. So I could do a field study, could go down to the Algonquin courthouse, I could sit in and listen to a trial, I could code whatever I wanted to code, and then I could, wait to find out what the verdict is. Okay, any questions about this? No, okay. I did not cover juror aids. It's in the textbook. There's been ways, or people have suggested ways to increase jurors' comprehension and understanding of what's happening in a trial. So one of them is to let jurors take notes, just like you in the classroom would potentially take notes. They could take notes, right? And they could, highlight things as the evidence is being presented. In the textbook, it talks about the pros and cons for note-taking. So you do need what are the pros and cons for note-taking. So this is on page 205, if you want to be even more specific. The other option is for jurors to ask questions, so that they actually, right now, they just sit there, right? The 12 of them sit there, they listen to the lawyers, they listen to the experts, they may listen to the defendants. They don't get to ask questions. But there's been a suggestion that maybe we should let them ask questions, and that might clarify issues for them. Okay? So certainly there are also pros and cons of allowing jurors to ask questions. So these two techniques have been suggested as options, right, to increase jurors' comprehension, perhaps attention to what's occurring. Now, there are concerns, for example, with note-takers, that the note-takers might really be the people who sway the decision-making in the group deliberations. Because if they've taken all these notes and they're in group and the rest of them haven't, maybe there might be too much reliance on these note takers. So that's one of the cons, excuse me, to note taking. Jury decision-making models. There's two general models described. The mathematical model, where the idea is that you sit there and you make calculations about how much evidence you're going to weigh. Oh, this is DNA evidence. I'm going to give a lot of weight to the DNA evidence. This is eyewitness evidence. You guys would probably say, I'm not going to give a lot of weight to the eyewitness evidence. And then you do some sort of mathematical summing or calculation, and that's going to relate to your verdict. That has not been supported in the empirical research. The other type is called the explanation or the story model, okay, where people come in with prior beliefs and expectancies about a specific type of crime. They will then listen to the evidence, and they'll make a narrative, a story that maps onto, right, what they believe. Okay, so their prior beliefs, and then they'll listen to what's happening, and then they'll come up with a nice, clear story. Then they'll map the verdict options onto that story, okay, and that's potentially that's how they'll make their decision. There is evidence supporting the story model. Okay, so they've actually done studies where you have a group of 6 people talking through a deliberation, recording that information, and then coding that information, and there's more evidence for the story model. Then we talked about predicting verdicts, and in your textbook, it's got things like demographics, race, gender, personality traits. I talked about race, that study looking at whether someone was death-worthy or not. In that study of African Americans in capital hearing, there was a study that I presented on physical attractiveness of the defendant relating to less serious sentencing and fewer verdicts of guilt. Okay, so you should know what predicts verdicts, both in terms of victim characteristics and defendant characteristics. Okay? And then there was, at the end of that chapter, there was a big section on, in that chapter, Regina Schuler was profiled. She is a researcher, does a lot of research on jury decision making. She used simulation designs. She did this one study that I also covered in the classroom, looking at the effect of expert testimony on battered woman, in the case of a battered woman. Okay? In that study, jurors read, right, a vignette describing the case of a woman who had been beaten, killing her husband. Then they were randomly assigned to 3 conditions. Either no expert, so they didn't hear any expert testimony, a general expert, where they heard an expert talking about battered woman syndrome, just in general, and then they had a specific expert. And this specific expert said this individual defendant, this woman, actually has battered woman syndrome. If the specific expert testified in that condition, there were fewer number of guilty verdicts. So more of the participants voted that she had killed in self-defense. So certainly expert testimony, particularly in the area of battered woman syndrome and women who kill, has a major impact on jury verdicts. I think I've summarized that more or less. Okay, we're all fine with jury decision making? You're fine, you're nodding, so keep going. Okay, so here's the question. Some of you have read the question already. Here's your multiple choice question. The Morgan, Tyler, and Latimer cases discussed in your text, oh, this is too easy, are illustrations of 2. Jury nullification. Okay? Now, I know it's quite easy. I just mentioned the Latimer case, but anyway. I think you'll see the term jury nullification on this exam here. Okay, which of the following methods of researching jury behavior is least likely? Now, there are some negatives on the exam, but I minimize them. So there will be some nots, and there will be some least, and there will be some untrue or false. So you need to pay particular attention when you say least, not, etc. So which of the following methods of researching jury behavior is least likely to be used in Canada? Yell it out. 2. Okay. Both lecture and page 203, I talked about this. If I asked you which was the most likely to be used, the answer would be 3. Okay, so most is simulation studies. Right? Just think of that's the easiest way to do the research. Okay. Which of the following defendant characteristics has been found to influence a verdict? 1? Do we agree? Is it 1? You think so? It's 1, physical attractiveness. Okay? So both the lecture on page 213. Okay. Okay, I think you're going to do well in that chapter. Okay, chapter 8, mental disorder. This is where you talked about mental disorder, fitness, and NCR. Now, the only cases that I will talk about or ask about on the exam are the one. Is that true? I think it's true. You do need for sure these 2 cases, the Pritchard and McNaughton case. So the key case for fitness is the Pritchard case from the UK. In this case, this guy was a deaf mute who couldn't plead to the indictment. So the criteria for fitness to stand trial was developed at that time, where this individual needed to be able to plead to the indictment. He was a deaf mute, so he couldn't. They also felt that he needed to be able to understand the proceedings. Well, he couldn't hear the proceedings, so it was very hard for him to understand what was happening. So certainly the Pritchard case is a key case because our criminal code is based on this case. The Criminal Code of Canada, actually before I say anything about the criminal code, there's 2 goals for why we want someone to be fit to stand trial. First of all, we want to make sure the trial is fair for the individual and is accurate. So if you believe your defense lawyer is working with the devil, right, you might not disclose pertinent information that would help your case because you don't want to disclose things to the devil, right? So it wouldn't be a very fair or accurate trial if we went forward in that circumstance. So there's two goals. It's not up here on the PowerPoint, but there's two goals for why we want someone to be fit to stand trial. The criminal code is it lays out three, so you need to know the three different criteria for fitness. One, you need to understand the nature of the proceedings. You need to understand the consequences of what's happening, and if you maybe agree to a plea bargain, you'll need to know the consequences of that if you're facing a dangerous offender hearing. And you need to communicate with counsel. Okay, so remember those three criteria. The assessment, only physicians can do fitness evaluations in Canada. It's not true in the States, but it's true in Canada. Only medical doctors can do fitness and not criminally responsible evaluations. The how, I went through two tests in class. In your textbook, in one of the boxes, it gives you about 5 or 6 different fitness evaluations. Don't worry about all 5 or 6. Worry about the competency screening test. That was that 22-item sentence completion test that I described in class, and it's described in that box. And the fitness interview test. Okay, so that was developed here in Canada. Okay, so those are the two you need to focus on, not the others that are in that box. Remember, I had a graph showing you the process and what happens to the individual. I indicated that fitness evaluations is very common in Canada, right? So there's about 5,000 fitness evaluations in Canada. In most cases, individuals are actually found fit. So in 80% of fitness evaluations, most individuals are found fit. In only 20% of cases, they're found unfit. Yep. The competency screening test, that's a 22-item sentence completion. The judge felt, and then you fill in the blank. And the fitness interview test, okay, from Simon Fraser. What else? Oh, yeah. Let me think. And then you need to know how you can proceed down and what will the options be, right? If you're found fit, if you're restored to fitness, either primarily through medication, right? Then you go back and you stand trial. So you do need to know that, what happens to an individual. Restoration of fitness, there can be a treatment order in order to force you to, or allow the physicians to force you to take medication. Okay, so even though you're refusing, you don't want the medication, there can be a treatment order saying you must take this medication. You cannot be forced to undergo surgery or ECT. Those are the two things you can't be forced to do. So yes, we can force you to try to restore you to fitness. We have 60 days to restore you to fitness, and then you can go from there. Okay, any questions about this? Okay, so I'm done with, you're all fine with the fitness to stand trial? Okay, not criminal responsibility on account of mental disorder. Daniel McNaughton is the most famous case. That's what our criminal code is based on. Daniel McNaughton suffered from a delusional disorder. He attempted to assassinate the Prime Minister of Britain and then missed and killed his secretary. Okay? So in the case of our Section 16, what you need to remember, you do need to have a mental disorder. And this is true for fitness to stand trial. So how these two legislations are similar, both need a mental disorder. So that's how they're similar. Okay? In the case of not criminally responsible, if the person, because of a mental disorder, does not know the nature or quality of the act, or does not know the act is wrong, then this is an actual defense. Okay? Fitness is not a defense. Fitness only delays the trial, right? until you can be restored to fitness. But NCR-MD is an actual defense. There will be an outcome resulting from the NCR-MD. So what happens to defendants found not critically NCR-MD, right? Absolute discharge, conditional release, or being sent to a forensic psychiatric hospital. Then I talked about review boards that will review the individual's case, and then depending on their risk level and their, how they're responding to treatment, they may well be released. And I described the Ehrenberg case. The Ehrenberg case here in Ottawa, Jeffrey Ehrenberg killed Brian Smith. He initially was found unfit. He was restored to fitness. Then he was found not criminally responsible. So a good case example that covers both fitness and NCR is the Ehrenberg case. So characteristics of those people found unfit would be, or sorry, not criminally responsible, would be most, and actually it's true for unfit too, mostly male, single, unmarried, and let me just make sure I get everything. Both for fitness and NCR have a psychotic disorder. And for those who are found not criminally responsible on account of mental disorder, majority of them have been charged with assaults or threats. I think it was 59% were charged with assaults or threats. Okay, so think of someone who's psychotic. That's not probably, you know, they're not out there doing armed robberies or sexual assaults, right? They're probably out on the street. Their delusions are making them, you know, think there's threats out there, so they're responding to those threats. In terms of what's missing from your slides, and I added last night, so I also covered common misconceptions relating to the NCR plea. Okay, and these, I'll just list them here. The common misconceptions were that a large number use this plea. That is very popular. Right? You're trying to get off, so you're going to claim insanity or claim NCR. It's actually very rare. Only 2 cases in 1,000, right, is this plea being used. So it's very rare, even though the public thinks it's used a lot. The public also believes that it's very successful. Like the most people who go forward with NCR are deemed to be not criminally responsible. Certainly, some of the high-profile cases, like Vincent Lee, the fellow that decapitated the individual on the Greyhound bus, he was found not criminally responsible. But the majority of other cases, and only 25% of evaluations or hearings, are people found NCR. What else do they believe? They believe that these individuals are released really quickly. So this is sort of a way to get around serving time. It certainly depends on the type of offense they're convicted for, but on average, individuals here in Canada who found NCR spend about 7 years incarcerated. And if you think that most of them are being charged with assaults or threats, there's no way you're going to spend 7 years in the prison for that. You may not even have got incarceration time for that. So typically, actually, these individuals are spending more time rather than less time if you control for the type of offense they commit. And finally, there's a belief that these individuals are really, really dangerous. Certainly the media says, oh, they must be really dangerous. Certainly, if you match, again, for offense type, individuals found NCR have lower rates of recidivism. So I call these misconceptions because there's not empirical research to support them. Okay? Is that? Okay. No questions? Okay. I've mixed something. Okay. So unfit versus fit. I already told you the distinctions, the similarities that they both need mental disorder. The distinctions are different legal outcomes. I already mentioned that, right? A delay in trial for fitness, NCR will result in, is a defense. For a fitness, you don't have to admit you're guilty, right? You don't have to say you're guilty. For NCR, since this is a defense, you have to admit guilt. Say, yes, I did it. Then we will talk about what's the impact or the outcome. So that's another difference. And the third difference relates to the temporal period being evaluated. Fitness is the current mental state, right, because you're at trial. You might have done the crime 1 year ago, 2 years ago. Not criminally responsible is mental state at time of offense. So you're going retrospectively back to when they committed the crime and what occurred. I also talked about automatism, unconscious, non-involuntary behavior, right? So you engage in behavior that you're not conscious of. And you can think of the most famous case in Canada. Does anyone remember the most famous case happened here in Ontario? Come on. Does anyone remember what occurred? Yeah? Good. Okay. So yes, he woke up in the middle of the night, drove 23 kilometers. Okay. Details. Fabulous. Okay. So he killed his father-in-law and attempted to kill his mother-in-law. Well, he was sleepwalking. Okay. So sleepwalking. Just think of sleepwalking. That is non-insane automatism. It results in an absolute acquittal. So he wasn't given any time. That's an absolute acquittal. Okay? There's also that was sane automatism. I'm trying to mix you up. That was sane automatism. Insane automatism results in going back to Section 16 and reverts back to Section 16, not criminally responsible. I talked about rates of mental disorder in offenders, and I had that one table looking at community samples versus offenders, and offenders have higher rates of pretty well every type of mental disorder. So certainly they're a group with many different mental disorders. Okay, so let's try to get you working here. Which disorder is most common in male offenders? I hear antisocial personality disorder. Any other choice? Come on, I hear it, I think. Someone's whispering it. Thank you. Oh, yeah, I couldn't hear it. Substance abuse is most common. Second most common is antisocial personality disorder. But substance abuse disorder is by far the most common disorder, followed by antisocial personality disorder. Okay? What else do you need about mental disorder? Okay, I didn't talk about mental health courts or treatment. That is in your chapter, treatment of mental disorder. And most common form of treatment of individuals found unfit to stand trial in NCR is medication to control their psychosis. In Canada, and in particular in Ontario and a number of provinces, they've developed what's called mental health courts. So these are unique courts that are dealing solely with individuals with substantial, serious mental health difficulties. They were established because of the belief that these individuals should not be sent to prison, but we should try to get treatment for them. Okay, so in Toronto, we have a mental health court. It goes back to about the mid-1990s, where individuals are diverted, if they have major mental disorders, are diverted to that mental health court. There hasn't been a lot of evaluations done on the effectiveness of these courts. Certainly, there are special prosecutors who are very familiar with mental disorders. There are judges who are very familiar with different types of mental disorders, and the defense lawyers who are familiar. So the idea is that they're going to work together sort of in the best interest of these mentally disordered individuals, rather than getting them cycling in and out of the criminal justice system. So yes, the answer is they do seem to be meeting the goal that the mentally disordered individuals are getting treatment sooner. The mentally disordered individuals going through the mental health courts find them more supportive than the regular courts. But there hasn't been any evaluation saying, or is the ultimate measure of success, are we stopping this cycle coming in and out of the criminal justice system? So we don't know whether that's happening or not. Okay, I think that's what was covered. Let me go back. Okay, any questions? Okay, so as currently specified in the Canadian Criminal Code, a defendant is unfit to stand trial if he or she is. I won't read. You can read them. Answer. Yeah, you have to get that. Say it out loud. Up there. What number? What's the answer? Someone at the back. No, they don't know. Well, who knows the answer? 4. Okay. You all know the answers. I'll get them moving. Okay, unable to. Okay, hopefully that's pretty clear. I covered in the lecture, and it's page 221 and 222 of your textbook. The next one is probably too easy, too. What standard is the insanity defense in Canada based on? One McNaughton standard. I mean, okay. Okay, this might be more difficult. According to prevalence rates of psychiatric disorders in the sample of Canadian offenders, Bland et al. 1990. It's in your book, and I had Bland et al. In that table. Less than 5% of male defendants from the Edmonton Remand Center are found to suffer from which one? So less than 5%. 4. That's right. Schizophrenia is relatively rare in defendants. Okay. Okay, so I don't know. I mean, certainly that's. I mean, it's about 2%. Okay, so it's. I mean, obviously it's not going to be antisocial personality disorder, right? We know it's not going to be substance abuse disorder. So you can get rid of 2 and 3 are easy to get rid of. Okay, I'm going to go on to sentencing. How are we for time? Oh, we've got lots of time. Okay, so incarceration rates. Remember, I had that table looking at the figures, looking at incarceration rates. The top country in the world is United States by far in terms of incarceration. And I talked about why that might be. Purpose of sentencing. You'll need to know the 7 different purposes of sentencing. Okay. And I won't give them here, but there are 7 different reasons why a judge will sentence someone to a specific type of offense. You'll need to know what are the sentencing options. Okay, you've got a whole box in Chapter 9 covering sentencing options, from absolute discharge to probation, restitution, fines, community service hours. The most recent sentencing option that has been implemented by Canada is the conditional sentence that was introduced in 1996. Okay? And of course, then we have the option of putting someone in prison. If they're put in prison for 2 years less a day, they go to the provincial system. If they get put in prison for 2 years more, they go to the federal system. Certainly, sentencing, the judges should take into account the sentence should be proportional to the gravity of the offense. So murder should have a longer sentence than maybe assault, right, than threats. And should take into the degree of the offender responsibility. So there's 2 things the judge are specifically asked to take into account. Okay, then I talked about types of sentencing disparity. This is, again, also in the textbook. There's systematic and unsystematic sentencing disparity. Systematic is when there's consistent disagreement across judges. So they just think that certain types of offenses should not have a very serious or stringent sentence. So there's consistency. But then there's unwarranted disparity or unsystematic disparity. And that is where you commit one offense. I don't know, you do a B&E. Okay? And then you do a B&E, same offense, same criminal history, everything's very similar, but on one day, I'm in a bad mood, I'm the judge, and I give you a 2-year sentence, and I give you 6 months. Okay, so that's unwarranted. It's based on my mood on that particular day that I'm giving differential sentences. Now, if I always gave lenient sentences to B&E, that would be a systemic disparity. Certainly, studying sentencing disparity, you can look at official statistics. And I had that graph across the different provinces, right? Driving while impaired versus assault. What is the percentage times individuals are incarcerated? So certainly you can look at official statistics. Or again, like in pretty much all the research we've covered in different areas, jury decision making, same thing with sentencing, you do a simulation study. So the McFadder simulation study is described in your textbook. I did not talk about McFadder. McFadder is from the United States. It used U.S. Judges. I talked about the Pallas and Dvorsky case here, Canadian judges. Remember, there was, I think it was 206 provincial judges. We gave them, these researchers gave them vignettes, 5 different types of offenses, and then they asked the judge to give a sentence. And when you looked at the table, I had minimum versus maximum, then I had average sentences. You saw major discrepancy or disparity between judges. And this was on the exact same case, right? Everything was identical. I then talked about the death penalty. I mean, you should know certainly that we don't have the death penalty here in Canada, abolished in 1976. I talked about characteristics of death penalty individuals, people on death row, being mostly male, about half African American, half Caucasian. Very high rates of mental disorder on death row inmates. I talked about the death row syndrome that develops after spending, 10, 15, 18 years on death row. I talked about about 30% of death row individuals have very low IQ. Okay, so those are the characteristics of the death row inmates. Then we talked about the pros and cons. So you need to know the pros and cons relating to the death penalty in terms of, is it a deterrent or not, for example. Okay, what was missing from my slide that I put up on Thursday is the other area that we talked about here in class and in your textbook was dangerous offenders. Our ultimate penalty, right, is a dangerous offender label. We got rid of the death penalty. To be labeled a dangerous offender means that you get an indeterminate sentence. It's not 5, 10, 15, 30 years. It's indeterminate. And I also talked about long-term offender. Okay. In that chapter, and I didn't spend much time talking about treatment, but you do need to know these 3 principles of treatment: risk, needs, and responsivity. This was developed by Don Andrews and Jim Bonta here at Carleton. Don has now retired. He was one of I would think it was the most famous forensic psychology here at Carleton, was Don Andrews. You'll see his research cited around the world. Risk principle: the higher risk you are, the more intensive treatment you need, right? If we're going to treat someone, we want to target treatment to the higher risk individuals. Needs: you should focus on dynamic criminogenic needs rather than non-criminogenic needs. A criminogenic need is something that's related to recidivism. So you need to target those needs if you want to reduce recidivism. People can have a whole host of needs, but in the context of correctional psychology, that's the type of need you need to target for your treatment programs. And responsivity means that you should match the treatment to the abilities and learning style of the offender. Okay, so you want, one size doesn't fit all. We want to match treatment to offender traits, characteristics, abilities. Okay, so that's the risk, need, responsivity principle. In your chapter, it talks, when we're talking about criminogenic needs, it talks about 4 really important needs. Those are known, or used to be known, and still are known as the Big 4. Now on the quiz, I noticed that I asked about the Big 8. And someone came to my office and said, well, you never talked about the Big 8, and where's the Big 8 in this textbook? I said, I'm sure the Big 8's in the textbook. I couldn't find the Big 8 anywhere. So let me tell you what the Big 8 is. Big 4, right? Antisocial history. This isn't your textbook. Antisocial history, antisocial associates, hanging around with antisocial peers, antisocial attitudes, right? Pro-criminal attitudes, and antisocial personality. So those have always been known as the Big 4. those big four, if you're going to assess risk in someone and you have limited resources, definitely select those four. Those are the most robust predictors of reoffending in general. Don Andrews and Jim Bonta expanded that list from the big four to the big 8 to include substance abuse as being a risk factor, family problems, and you can think of that desistance lecture that Caleb talked about, employment problems. Okay, so the extra four are substance abuse, family difficulties, relationship difficulties, employment problems, and having nothing to do with your leisure time. Okay, so those are the big 8. Okay, if I ask you, it's not on that slide either, the most effective type of treatment with offenders would be what? What's the most effective type of treatment? Uh-oh. I don't know, psychotherapy? No? Pet therapy? For me it might be, but maybe not for offenders. Art therapy? Okay, come on. What would be the most effective type of treatment? Certainly Kevin Nunes mentioned it in his guest lecture. It's also in the textbook. Okay, I'll tell you because we don't have much time. Cognitive behavioral treatment. Okay, cognitive, right? We want to change their attitudes. We want to change their behavior. So just remember cognitive behavior treatment. What else? Parole decision making. I don't think I spent much time talking about parole decision making. There's a whole section in your textbook on parole decision making. You need to know that there is a National Parole Board that will make decisions about release. The National Parole Board will take into a whole host of factors. So you should focus on what factors the National Parole Board takes into account when making a decision. And the answer is yes, they do take into account victim statements. A victim can come to the National Parole Board hearing and make a statement. Obviously, they take into account criminal history, the person's insight into offending, their level of remorse or responsibility, the risk assessments from the psychologists and psychiatrists, what sort of change and what sort of treatment they participated in. Takes into account past performance on conditional release. So all of those factors you should be familiar with. Where are we? Types of parole. Okay. Temporary absence, the first thing that can happen, either escorted or unescorted, right? So your mother dies, you want to go to the funeral, you just got put into the institution, they can escort you to the funeral, so you can attend the funeral. Then there's day parole, full parole, and statutory release. Okay, so you should know each of what each of those mean, right, as relating to a conditional release. You need to know, excuse me, what about public attitudes? Right? I spent some time in class, and I even gave your feedback from your assignment about attitudes towards the criminal justice system, attitude towards the court, attitudes towards the police. The public thinks we're too lenient in terms of sentences that we impose. The public thinks that most people get out on parole. There's a whole text box in this Chapter 9 talking about myths surrounding parole. So you need to think about, read that in terms of those myths. And the public has most confidence, and actually you guys did as well, in the police. So we think our police are doing pretty well. We're not so sure about the correctional service. We're not so sure about the court, nor we're not so sure about the National Parole Board. Okay. Sentencing an offender with the intent of reducing the probability that members of the community will violate the law is known as Five. You do need to know the difference between specific and general deterrence. Okay? Which of the following statements are true regarding the death penalty in the United States. Okay, so you just go through them. And there are, I know you don't like all of the above, none of the above. There are some all of the above and none of the above on the exam. So certainly yes, but the majority of Americans are in favor. Yes, there's been 123 DNA exonerations. Yes, it's true, it's not an effective deterrent. There's been research comparing states that have implemented the death penalty or states that are side by side. And yes, the death penalty is administered in a discriminatory manner, so it's all of the above. And that was directly from the lecture I gave on death penalty. Okay, the first type of release an offender is typically granted is what number? 4. Yeah, I just mentioned that, right? You want to get out to go visit, right? So temporary absence. There's no such thing as partial parole, so you can just get rid of that. Okay, Chapter 12, risk assessment. You need to know when a risk assessment is conducted. Right? There's huge number of settings where risk assessments are conducted, right? School threats, right? Release decisions. Dangerous offender legislation, sentencing options, where are you going to send a person in terms of custody? Okay, duty to warn evaluations. Okay, child custody evaluations. Yep. Well, it's Chapter 12. I moved it ahead because I thought it fit in better. So certainly risk assessment is definitely Chapter 12. Okay. Types of prediction outcomes. Do I have time? You should all be able to make this 2 by 2. Maybe as soon as you get into the exam, make this 2 by 2 because you can memorize it just before you step into the exam. Okay? So this is high risk. I don't know how. This is low risk. This is your prediction. This is what you predict. This is your outcome when you follow them out, right? This person was violent. This was not violent. This is outcome. So you might not be able to read that. Okay, so you're going to predict someone is likely to reoffend, and they do. What's this called? Oh, good. True, because it's true. It is true, correct, right? And it's positive. Okay, so you predict someone's going to reoffend, but they do not. Well, it's going to be false, so at least we can get F there. That's good. It's a false. Thank you. False positive. Okay? Now okay, so down here you predict they will not reoffend, but they do. So it's an error, so it's a false negative. Well, obviously this is going to be a true negative. Okay, so burn that in your frontal cortex or your hippocampus or wherever it goes. Okay, so you got that. Okay. You need to know about the 3 different types of risk assessment. Unstructured clinical judgment. This is where you just use your intuition, your experience. There's no set number of risk factors, so this is sort of the old style of decision making. You need to use, then came the actuarial, right, where you're very specific. It's developed by, you do a research study, you have these range of risk factors, you then statistically determine that these risk factors are supported by saying that this is what's related to the outcome. And the more recent type is structured professional judgment. Okay? So you need to know what are the characteristics of each of those 3 different types. You need to know what's the difference between historical static risk factors and dynamic. And certainly that was covered in the risk assessment. Kevin covered it in the sex offender assessment as well. So certainly need to know that. You need to know what are the important risk factors in terms of demographics. Young age male are certainly the 2 demographic risk factors that are being replicated. Historical are things like past criminal behavior. Past criminal behavior is going to predict future criminal behavior. Age of onset, the younger you are, right? This is a historical, that you start engaging in antisocial behavior, is a risk factor for future criminal behavior. History of childhood maltreatment. Now, these are all historical, right? We can't change these. There's something that happened in the past. Past supervision failure. So I've just given you some examples there. In the textbook, you have these headings: demographic, historical, clinical, and contextual. Clinical risk factors would be things like substance use, psychopathy, threat control override symptoms. Okay, so I've given you 3 examples there. And contextual will be what's in the environment. So whether or not you have social support in the environment, do you have access to victims or weapons? That would be an example of a contextual risk factor. In your text, you have, and near the end of the risk assessment, we talk about these risk assessment measures. And there's individual risk assessment measures for general reoffending, for violent reoffending, for spousal assault reoffending, and sexual reoffending. To save you time, you do not need to know the names of any of them. So you don't need to know about the LSI, the HCR20, the SARA, the static, I don't know, the VRS. I don't know how many they go on, right? There's about 6 or 7 specific risk assessment measures. Read about them, but you don't have to commit them to memory, okay? You do need to know that there are different risk assessment measures developed for different outcomes. So at that level, you need to know that, right? There's specific risk assessment measures. Kevin Noon spent a lot of time talking about the SONAR and the static 99, but you don't need to know the names. You just know that there are specific measures. Protective factors, you should know that there's not much research on protective factors, but certainly this is a growing area, so that there are things like social supports, good coping mechanisms, high IQ, right? Attachment to pro-social others, pro-social attitudes in terms of wanting to work or wanting to stay in school. Those are all protective factors that might mitigate someone's risk level. And what wasn't mentioned, but put it in red because it wasn't on your slides either, you need to know Ed Zambles. It's in a box in Risk Assessment chapter, talking about the coping relapse model. So you need to know that model and the components of that model. Okay? Okay, in predicting, it's pretty obvious. In predicting violent acts, A is an incorrect prediction in which a person is predicted to be nonviolent but acts violently. That is number 4. Okay? If you have that up on the board, you'll be fine. Okay, a possible decision error made by clinicians in which it's believed that a correlation exists between 2 events that are in fact unrelated or correlated to a lesser degree is defined as, I hear 2. Now, I did not cover this in class, but remember I always told you a hint. If something's in the question like correlation, right, and the only thing in the alternatives is correlation, that's a good way, even if it had no clue what the answer is. Now, certainly this illusory correlation was one of the glossary terms in that section, so you should have known that anyway. Dr. James Grigson was a psychiatrist known to use an approach to risk assessment. That crazy guy in Texas? 1. Okay, 1. Unstructured clinical judgment, right? He was also notorious in the area of psychopathy as well. Okay. Then we had Caleb come in, talk about exiting crime. So really, I think there's 4 questions on the exam, maybe 5. He gave me 10. I selected them from the multiple choice he gave me. You need to know what the age crime curve looks like, right? That crime peaks in the late adolescence and then drops off or declines around age 30, 35. So you just draw that sort of age crime curve. He talked about the reasons for the age crime curve. Maybe we talked about testosterone, burnout, neurotransmitters, learning different ways to evade detection. Maturation was also talked about there. He talked about the different trajectories in terms of pathways. So there was adolescent limited, okay, those individuals who commit crime typically only in adolescence. Okay, there were low-level chronics, those individuals who committed crime, and they were pretty chronic, but not very high levels, or not a great deal of crime. He talked about high-level chronics, and this is what everyone worries about. right? The high-level chronics are those individuals who commit crime early onset. Both the chronics commit crime at early onset. Okay, but they vary in terms of the amount of crime they commit. So most of us would be worried about the high-level chronics. Right? They're committing lots of crimes, they start early, and they stay committing crime. And then there was the late onset group. So we had that nice graph that had these different, oh, I won't have time. But anyway, you should go back to his lecture if you don't remember them. Desistance, he talked about stopping substance abuse. We know substance abuse is one of the big 8 risk factors, right? We know that majority of offenders have substance abuse problems, so certainly it's something that we want to target in order to encourage desistance, exiting crime. He talked about a good quality marriage, right, where you're married to someone who's pro-social and encourages you and supports you. And he talked about employment. Okay. He had a slide talking about how desistance is a process versus a single event. Right? It's not something you just stop. You can think of trying to stop smoking, right? How some people try and then they go back into it and they have to try again and again. That's what exiting crime is similar to. He talked about crime expectancies, right? We had positive, negative crime expectancies. Then he had positive, negative desistant expectancies. So you need to know examples of positive and negative crime and desistant expectancies. And he also talked about desistant effort. So there was 3. There was crime expectancies, desistant expectancies, and effort involved, right? And all of those, he had that beautiful model that he put up on the screen that those guys, Ralph Saron and him, are testing, right? That model looking at the association between these things. And then at the end, he talked about implications for the criminal justice system in terms of rehabilitation, treatment, and knowledge of adult development. I know I'm going faster, but I've got 2 more chapters to go through. Okay, age crime curve. What's the answer? The age crime curve. No one knows? 2. Okay. I sort of mentioned that right now. Okay, you're going to get this one. The main reason marriage is correlated with giving up a crime is because 2. Right? High quality marriage. Right? To make good changes. Okay, we've got 2 more chapters go. We got chapter 10, and then we got the last chapter. So I'm going to go a little faster because these are chapters that we covered in the last few weeks. Domestic violence, I talked about the prevalence of domestic violence. I talked about that international dating study that wasn't in your textbook, right? Looking at and the most common scale used to assess domestic violence is the conflict tactics scale. At the beginning of that chapter, it goes through lots of details of the conflict tactics scale, the problems with the original conflict tactics scale, and then how they changed it. I talked about different theories. Remember I had that power and control wheel. That's what relates to the patriarchal attitudes belief that men are dominant and they want to control women in society, and this is what leads to the motivated by power control, and this is what leads to domestic violence. Then I spent a lot of time. So I spent a lot of time on social learning theory. Okay, so you need to know how social learning theory has been applied to explain domestic violence. And there's 3 different components that you need to be familiar with. So certainly go back to both the textbook has it in it and my lecture notes has it in it. We talked about why do battered women stay. Well, we talked about why they stay, why they leave, and why they come back. Okay, so all 3 of those areas were talked about. I talked about the typologies of male batterers. There's 3 different. You need to know those 3 different types of male batterers and the characteristics associated with them. I did not talk about criminal justice response, but there's certainly the Burke study in your textbook looking at mandatory charging and the effects of mandatory charging policies and whether it reduces recidivism or not. And then there's also the meta-analysis in your textbook talking about treatment. And basically, there's a very small treatment effect. Okay, so that was domestic violence. Kevin came in and talked about sex offenders. So he talked a lot about characteristics of sex offenders. He talked about assessment of sex offenders. He talked about treatment of sex offenders. What's also in your books are different types of sex offenders. So you need to know the different types. Voyeurs versus exhibitionists versus rapists versus pedophiles. So along the glossary or on the side in the margin, they talks about these different types. You will need to know the typologies of different child molesters and rapists. So it wasn't covered in the lecture. It's in your textbook. Certainly, Kevin touched on the different theories of sexual aggression. And again, that's also covered in your textbook. Kevin did not talk about female sex offenders. You need to know about female sex offenders and the different typologies associated with female sex offenders. Kevin talked a lot about treatment targets. Like, what do we target in treatment? Cognitive distortions, lack of empathy, poor social skills. Certainly one of the major risk factors for sexual recidivism is deviant sexual arousal and interest. And then he talked quite a bit about treatment effectiveness. Okay, so you need to know that. Okay, I'm just going to give you the answers because I know we're getting close to the end. So intimate partner violence consists of physical, sexual, emotional, and financial abuse. Financial abuse was used in your textbook. I use economic abuse in my lecture. They mean the same thing. Okay? So that's the right answer, would be financial. Which type of male batterer is most likely to exhibit jealousy? It would be the dysphoric borderline batterer. Now this is a huge, I know it goes on and on. The treatment approach that attempts to reduce recidivism among sex offenders by increasing self-awareness of factors that place them at high risk to reoffend and teach them how to manage these high-risk situations is called. Now, I don't think Kevin spent much time on this, but there's a whole box describing this treatment program. It's a part of any treatment program for sex offenders now, and the answer is relapse prevention. So you do need to know about relapse prevention in the treatment of sex offenders. Okay, we're on to the last chapter you need to know. And I think I can go through this fast because we just talked about homicide and psychopaths. So you need to know about characteristics of homicide, the different types, infanticide, you know, kids who kill, domestic violence situation where homicides take place. You do need to know, characteristics of homicides talks about the crime rate, the homicide rate, how we compare it to different countries, and the fact it's going down. And then I talked about different types of murderers, right, infanticide, etc. I talked about the bimodal classification, right, affective, reactive is the other term that I used, versus instrumental, predatory types of homicide. Okay, so you certainly need to know that distinction. You need to know about the different types of multiple murderers, right, mass murderers. I mean, it should be, right? Yesterday was the memorial for December 6th, the Mark Lepine shooting. He was an example of a mass murderer all at one place. Difference between spree and serial, you'll need to know. You need to know, I had that slide, and in your textbook, there's a table comparing male and female serial killers, the characteristics of male and female serial killers. There's at least 3 questions on typologies of serial killers. And this is on the Holmes and Holmes typology. Comfort-oriented, visionary, lust. If that doesn't ring a bell, then you need to go back and read about those, that typology. What I did not talk about, which you do need to know, is the trauma control model. Okay, there was a model that's been proposed to try and explain serial killer, and it's called the trauma control model, so you should know the components of that model. Then we move to psychopathy. So you need to know where the most well-known assessment procedure is the Sahara psychopathy checklist. 20 items. You need to know the features, the types of symptoms associated with the interpersonal, affective, behavioral, and antisocial. Remember, those are the 4 clusters I talked about. I gave you examples of symptoms. You need to know about that overlap between antisocial personality disorder, right? I had that figure and the overlap between the two. That a high percent of individuals are diagnosed with antisocial personality disorder, not so much with psychopathy. You need to know the link between psychopathy and violence, right? So psychopaths start early. They're high density offenders. They have high rates of recidivism once they get released. That's why they've caught the attention of the National Parole Board. I spent some time talking about psychopathy and treatment. Right, that Rice, Harris, and Cormier study. We also spent time talking about the implications of labeling. Right, so there was that capital punishment study, labeling in juvenile and adults. We talked about nature versus nurture, the research, the twin study research. And we talked about evidence for an affective deficit. Okay, remember the startle blink that I showed you? You'll need to know that study. It's described in your textbook. Okay, according to Holmes and Holmes, which of the following serial murderers is primarily motivated by material financial gain? 2. Okay, hold on, you guys. Another 3 minutes and you're ending. Okay, so just give me another few minutes. Which of the following is not a key feature of psychopathy? So I heard 4. 3, anxiety. Okay, psychopaths are not highly anxious individuals. Okay, according to the textbook, attempting to explain psychopathy by proposing that psychopaths has a response modulation deficit, actually I guess I did talk about this in class as well, is referred to as what type of model? Hurry, hurry. Someone yell out. 3, 1. Okay, I'll go with 1. It's a cognitive. It's Joe Newman's research. Okay, well, I want to thank you and good luck on your exams. So I'll see you next Monday. And one last picture. Have a relaxing break. Okay, we'll see you guys.